Contract formation. How contracts are formed. A contract is an agreement that's enforceable by the law. The agreement is made by offer and acceptance, and is generally made enforceable in the presence of consideration. The most important feature of a contract is that one party makes an offer for an arrangement that another party accepts. This can be called a concurrence of wills or meeting of the minds. As we will see soon, consideration means some form of barter. A contract can be formed by virtually any type of communication. It's not necessary that a contract be written or in any particular format. Contracts can be created through verbal agreements, silent gestures, even smoke signals. As we will learn, there's an exception to this rule. Contracts for the sale of real estate and other high-priced items will not be enforced unless they're in writing. What constitutes a writing is very broad. Handwritten notes, faxes, emails, instant messages are all forms of writing, so contracts come in various shapes and sizes. In legal parlance, the definitions of offer and acceptance are intertwined. An offer is an act by the offeror creating a power in the hands of the offeree to form a contract through acceptance. An acceptance is an act by the offeree agreeing to the offer and thereby creating a contract. The offer and acceptance can be written, verbal, via email or any form of communication. Acceptance in a unilateral, promise for an act contract is through performance of the act itself. As we will learn when looking into the statute of frauds, written agreements are required for the sale of real estate and other big-ticket items. However, as a general rule, a writing and signature is not necessary to form a contract. Offer and acceptance can be made verbally or through other forms of communication. A signature is, however, good evidence that an agreement was formed between the parties. A signature does not have to be a handwritten name. An X, a scribble, smiley face, anything can act as a person's signature. The court has even interpreted the letterhead on the top of an unsigned fax to act as a valid signature. There are no rules saying that the signature must be at the beginning, the middle, or the end of the contract. Electronic commerce would be impossible if digital signatures were not considered valid evidence of assent to a contract. In the year 2000, Congress passed the Electronic Signatures in Global and National Commerce Act, e-sign, ensuring the validity and legal effect of contracts entered into electronically. Although every state has at least one law pertaining to electronic signatures, it's the federal law that lays out the guidelines for interstate commerce. The general intent of the e-sign Act is that a contract or signature may not be denied legal effect, validity, or enforceability solely because it's in electronic form. Electronic signatures and records are just as good as their paper equivalents, and therefore subject to the same legal scrutiny of authenticity that applies to paper documents. Although two parties are required to form a contract, only one signature is necessary. A contract dispute usually involves one party asking the court to enforce the second party to perform his promise. One party is the plaintiff bringing the suit, and the other party is the defendant disputing the claim. It's not necessary that the contract has the signature of the plaintiff, only that of the defendant. So a contract that is signed by only one of the parties can be enforced against the party that signed. Many written contracts are multi-page documents that have been drafted by lawyers. Others are pre-printed forms. However, a written contract does not have to be either drafted by a lawyer or formally typed to be legally binding. Any written materials such as letters, telegrams, invoices, sales receipts, checks, handwritten napkins, stone carvings, and tattoos constitute writings sufficient to form a binding contract. As for the content, under the common law, writings forming contracts for services must contain all the material terms of the agreement. The common law essentially wants to know the who and the what. Who are the parties and what are they agreeing to? If these two essentials can be ascertained, even when they constitute only a handful of words, the document will qualify as a writing under the common law. When we're dealing with the sale of goods, the UCC is much more forgiving and will often fill in the who or the what if they're missing. The sale of goods often takes place between merchants, buyers and sellers that regularly trade with each other. So some of these regular trading terms can be added in by the court to complete the contract. The only term required by the UCC is the quantity, the number of goods being sold. A letter saying "send me 15 widgets" from one merchant to another will be deemed to be an order and form a binding contract. If the goods are not available and the seller fails to respond, informing the buyer within 10 days, the UCC will fill the gaps and assume a contract was formed for the seller to ship 15 widgets to the buyer. If the widgets are not shipped, then the seller could be in breach of contract. Although the seller did nothing to indicate acceptance, the UCC will assume acceptance was implicit in the lack of response from the seller. Merchants of goods in the US need to be aware of letters, emails, or written communications from other merchants, and take care to respond within 10 days if they want to avoid becoming party to contracts formed under the UCC. An offer is usually revocable by the person making the offer, the offeror. However, there are some exceptions to this rule. The first exception is where it was presented as a firm offer. The second involves reliance. If the offeree relies on the offer, then it's irrevocable. For example, if a main contractor receives an offer from a subcontractor and incorporates this bid into his proposal to the client, the main contractor is reliant upon the subcontractor's bid, and this bid is irrevocable. In a unilateral contract, where party A performs and party B pays upon completion of the performance, B cannot revoke the offer after performance has been commenced. So if B says to A, "I'll pay you $100 if you mow my lawn," B cannot revoke the offer after A has started to mow the lawn. If B has only started to prepare to mow the lawn, perhaps buying the gasoline for his lawnmower, then A still has time to revoke the offer. Mere preparation to perform is not sufficient to render the offer irrevocable. The offer becomes irrevocable when performance has started under a unilateral promise for an act contract. However, B may be able to claim the offer is irrevocable under the reliance rule. If B relied upon A's offer in buying the gasoline to mow the lawn, then the offer may be irrevocable on the basis of reliance. A house buyer may make an offer below the asking price. The seller then has the opportunity to form a contract by accepting the offer. If the seller rejects the offer is killed, and a contract cannot be formed by later accepting the rejected offer. A counteroffer acts as a rejection and a new offer, so this also kills the original offer, and the power of acceptance to form a contract is destroyed by a counteroffer. An acceptance conditioned upon different terms acts also as a counteroffer. So if the seller said she would accept the offer if the buyer agreed to buy her a new car as well as the house, then this would act as a rejection and a new offer. Instead of entering a counteroffer, the seller is better advised to hold the offer and inquire about a higher price or other terms. An inquiry about alternative terms is not a rejection or counteroffer, so does not kill the offer. A savvy seller in this situation will make sure the offer is not killed by a rejection or counteroffer, and will hold the offer under advisement while alternatives are explored. As we learned on the previous slide, a conditional acceptance usually acts as a counteroffer. This is consistent with the common law mirror image rule. To form a contract, the acceptance must be the mirror image of the offer. An acceptance that differs from the offer is classified as a rejection and a new offer, a counter. However, the mirror image rule does not apply for the sale of goods. The UCC states that a contract can be, and usually is, formed when acceptance adds terms or otherwise diverges from the offer. As merchants use form contracts for both purchases and sales, a battle of the forms and divergence of acceptance from offer is common in the sale of goods. As the purchase orders and sales forms used when selling goods are highly unlikely to match, we need a way of dealing with the frequent situation where the acceptance differs in some way from the offer. A contract for the sale of goods involving an acceptance adding terms to the offer is formed so long as the new term proposed in the acceptance is not a deal breaker. If the acceptance involves an express condition requiring express assent, this is a deal breaker and the communication acts as a counteroffer. "I'll accept your offer if you can deliver on Monday" would be a conditional acceptance. It's a counteroffer as the delivery on Monday is a deal-breaking term that has not been agreed to by both parties. No contract has been formed. However, "I accept, please deliver on Monday" would act as an acceptance and a contract would be formed. If the parties were both merchants, Monday delivery would become part of the agreement. If, however, one or both of the parties are not merchants, then the Monday delivery is treated as a proposal and does not form part of the contract. When we're dealing with the sale of goods under the UCC, when the parties are both merchants, the new term proposed in the acceptance becomes part of the contract. Of course, the new term does not become part of the contract if the term is expressly rejected in a subsequent communication. When the person making the offer dies with him. The acceptance must be made before the death of the offeror for the contract to be formed. There are other ways the offer can die. It can die when revoked by the offeror or is rejected by the offeree. If the offer was provided with a deadline for acceptance, it dies when the deadline is met. Deadline or not, an offer can die of old age. The power of acceptance terminates at the end of a reasonable period of time. What's reasonable depends on the circumstances of the offer and the proposed transaction. Of course, when the offer dies, so does the power to form a contract through acceptance. You cannot accept an offer that was made to your neighbor. An offer can only be accepted by the person or people to whom the offer was made. There is an exception, however, involving options. If your neighbor acquires an option to accept the offer, the neighbor can sell or transfer this option to you. Of course, this would be ineffective if the option was created with a restriction on transfer, but generally an option can be transferred where an offer cannot. Knowledge of the offer is also necessary to create the power of acceptance. This really applies only in reward situations. You have to know about a reward to be able to accept the reward. If you capture an outlaw and turn him into the authorities, then find there was a reward on his head, you may be dismayed to find that you are unable to claim the reward. You can't claim a reward that you didn't know about. Remember, the terms of acceptance are created by the offer. So an offer can create a power of acceptance in a large number of people if that was the express intent of the offeror. Silence alone is usually insufficient to constitute acceptance and form a contract. The offeror cannot create a contract by saying, "Your silence will be deemed acceptance of this offer." Acceptance requires some act or communication from the offeree. The situation is different, though, for the offeree. The offeree can override this rule by saying, "Unless you hear from me by Monday, your offer is accepted." In this situation, silence was identified by the offeree as his form of acceptance. Acceptance can be also achieved through silent performance. Performance usually acts as an acceptance of an offer. Let's assume the client offers the painter $100 to paint his house. If the painter silently starts to perform, then this is deemed acceptance of the offer and a promise to complete performance. Unilateral contracts form an exception. If the client's offer said that the acceptance was to be made through performance, then complete performance is necessary. Acceptance of a unilateral promise for an act contract demands complete performance of the act. Complete performance constitutes acceptance in a bilateral promise for a promise contract. The exception here is where notice of performance is necessary. For example, where the client offers the painter $100 to paint his vacation home and the client was unaware that the painting had taken place. In this situation, painter would have an obligation to give notice to the client that the painting had been completed before acceptance was effective and a contract was formed. When the two parties are at remote locations and communication takes place via mail or some delayed medium, there's often a situation of conflicting communications. Acceptances and revocations can pass each other in the mail. There are some established rules for dealing with these situations. The mailbox rule says that acceptances are effective when they're placed in the mailbox. So a contract is formed when the letter of acceptance is sent by the offeree, and before the letter is received by the offeror. The offeror may be unaware that the contract has been formed during the period of time that the letter of acceptance is en route. The opposite rule applies to revocations. The revocation is not valid until it's received. So what happens when the letter of acceptance and the letter of revocation cross in the mail? The answer depends on which one entered the mailbox first. If the acceptance was mailed first, then the mailbox rule applies and acceptance formed the contract upon mailing. If, however, the revocation was mailed before the acceptance, then the mailbox rule is suspended and the formation of the contract depends on which communication arrives first. If the acceptance arrives first, then the contract is formed. If the revocation arrives at its destination before the acceptance, then the offer is revoked and the acceptance is ineffective. Essentially, the contract is formed when acceptance is placed in the mailbox by the offeree, except where revocation has already been mailed by the offeror. Then it's a race to see which one arrives first. We know that the delivery of apples in response to an offer to buy apples acts as an acceptance and forms a contract. What happens when the buyer offers to purchase apples and the seller mistakenly sends him pears? Does the delivery of pears form a contract? The answer is yes. It acts as an acceptance, formation of a contract, and breach of the contract at the same time. However, if the seller delivers pears with a note saying, "You ordered apples, but we only have pears available," this is treated differently. This is treated as a counter-offer. So a contract is not formed by the mailing of the pears when it's accompanied with a communication suggesting an alternative to the goods requested in the offer. Contracts can be formed verbally, but the statute of frauds requires that certain kinds of contracts be made in writing. Traditionally, the statute of frauds requires a writing signed by the defendant in the following situations: contracts in consideration of marriage, contracts that cannot be performed within 1 year, contracts for the transfer of an interest in land, contracts by the executor of a will to pay a debt to the estate with their own money, contracts for the sale of goods valued at $500 or more, and contracts in which one party becomes a surety, acts as a guarantor for another party's debt or other obligation. So the courts look for evidence of a contract in these situations where it sees opportunity for fraud. A writing provides good evidence of a contract, but performance of the contract is also good evidence for the court to consider. A contract falling within the statute of frauds will be enforced by the court without a writing where full performance has been completed. Note that only full performance or a writing satisfies, but part performance of the contractual obligation does not satisfy the statute of frauds. However, when the contract is for the sale of goods, the UCC is more forgiving and will force the buyer to make payment for delivery of goods received, even in the absence of a writing.